Philippine Criminology Licensure Examination. Subject: Criminal Jurisprudence and Procedure. Question number 1. A complaint was filed before the Municipal Trial Court, MTC, for the crime of homicide. The MTC judge, after evaluating the complaint, dismissed it for lack of jurisdiction. Is the MTC judge correct? A. No, because the MTC has jurisdiction over all criminal cases. B. Yes, because homicide is a capital offense beyond MTC jurisdiction. C. Yes, because homicide is punishable by reclusion temporal, which falls within the exclusive jurisdiction of the Regional Trial Court, RTC. D. No, because jurisdiction depends on the penalty actually imposed, not prescribed. Correct answer: C. Yes, because homicide is punishable by reclusion temporal, which falls within the exclusive jurisdiction of the Regional Trial Court, RTC. Why C is correct? Under Batas Pambansa BLG 129, the Judiciary Reorganization Act of 1980, as amended by RA 7691, the Regional Trial Court, RTC, has exclusive original jurisdiction over all criminal cases where the penalty prescribed by law exceeds 6 years imprisonment. Homicide under Article 249 of the Revised Penal Code, RPC, is punishable by reclusion temporal, 12 years and 1 day to 20 years, which clearly exceeds 6 years. Therefore, the MTC correctly dismissed the case for lack of jurisdiction. Why the others are wrong? Option A is incorrect because the MTC does not have jurisdiction over all criminal cases. Its jurisdiction is limited to offenses where the penalty does not exceed 6 years of imprisonment, RA 7691. Option B is incorrect because homicide is not a capital offense. Capital offenses are those punishable by death, now replaced by reclusion perpetua under RA 9346. Homicide is punishable by reclusion temporal, not death. Option D is incorrect because jurisdiction over criminal cases is determined by the penalty prescribed by law, not by the penalty actually imposed after conviction. This is a fundamental rule in criminal jurisdiction. Edge knowledge: when determining court jurisdiction in criminal cases, immediately look at the prescribed penalty, not the penalty imposed. If it exceeds 6 years to RTC. If 6 years are below to MTC, MTCC, MTC. Question number 2. Officer Reyes arrested suspect Cruz without a warrant after personally witnessing Cruz stab a person. What type of arrest is this? A. Arrest by warrant. B. Citizen's arrest. C. Constructive arrest. D. Lawful warrantless arrest, in flagranti delicto. Correct answer: D. Lawful warrantless arrest, in flagranti delicto. Why D is correct? Under Section 5, Rule 113 of the Rules of Criminal Procedure, a peace officer or private person may lawfully arrest a person without a warrant when the person to be arrested has committed, is actually committing, or is attempting to commit an offense in the presence of the arresting officer. This is known as an in flagranti delicto arrest. Officer Reyes personally witnessed the stabbing, making the warrantless arrest lawful. Why the others are wrong? Option A is incorrect because an arrest by warrant requires the issuance of a warrant by a judge after finding probable cause. In this scenario, no warrant was issued, the arrest was made on the spot. Option B is incorrect because Officer Reyes is a peace officer, not a private citizen making a citizen's arrest. While private persons may also make in flagranti delicto arrests, the proper legal term for a peace officer's warrantless arrest under Sec. 5, Rule 113 applies here. Option C is incorrect because constructive arrest is not a recognized term under the rules of criminal procedure for valid arrests. It is a distractor with no legal basis in Philippine procedural law. Edge knowledge: remember the 3 valid warrantless arrests under Rule 113. 1. In flagranti delicto, committed in the presence of officer. 2. Hot pursuit. Officer has personal knowledge of the offense. 3. Escaped prisoner, escaped from prison, detention. The key phrase here is personally witnessing to in flagranti delicto. Question number 3. During custodial investigation, SPO 1 de los Reyes began questioning suspect Ramos about the robbery without informing him of his Miranda rights. Any statement Ramos makes, A, is admissible because the suspect voluntarily gave the statement. B, is admissible if the suspect signed a waiver. C, is inadmissible in evidence against him. D, is admissible if confirmed later in a sworn affidavit. Correct answer. Circa is inadmissible in evidence against him. Why C is correct. Under Article 3, Section 12 of the 1987 Philippine Constitution and Republic Act No. 7438, rights of persons arrested, detained, or under custodial investigation. Any person under custodial investigation must be informed of 1. The right to remain silent, 2. The right to competent and independent counsel, preferably of his own choice, 3. The right to be informed that any statement may be used against him. Any confession or admission obtained in violation of these rights is inadmissible in evidence. This is known as the exclusionary rule or the fruit of the poisonous tree doctrine. Without informing Ramos of his Miranda rights, the statements obtained are constitutionally infirm. Why the others are wrong. Option A is incorrect because voluntariness alone does not cure the constitutional defect. The Constitution requires that the suspect be informed of his rights regardless of whether he appears to cooperate voluntarily. Option B is incorrect because a waiver of rights during custodial investigation must be made in writing, signed by the person in the presence of counsel. Even if a waiver exists, if Miranda rights were not first explained by counsel, the waiver is invalid under RA 7438. Option D is incorrect because a subsequent sworn affidavit does not cleanse the initial tainted statement. The original statements obtained without Miranda warnings remain inadmissible, and courts are cautious about subsequent confirmations that are fruit of the original illegal interrogation. Edge knowledge. Any question involving custodial investigation plus no rights informed equals inadmissible. This is a constitutional guarantee under Section 12, Article 3. No exceptions unless rights were properly waived in writing with counsel. Question number 4. The following are instances of valid warrantless searches, except A. Search incidental to a lawful arrest. B. Search of moving vehicles. C. Consented search. D. Search of a private residence based on police suspicion alone. Correct answer. D. Search of a private residence based on police suspicion alone. Why D is correct. Under Section 2, Article 3 of the 1987 Constitution, every person has the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. A search based on police suspicion alone, without a warrant and without falling under any recognized exception, is unreasonable and unconstitutional. Mere suspicion does not justify an intrusion into a private residence. Why the others are wrong. Option A is incorrect as a choice for the answer because a search incidental to a lawful arrest is a well-recognized exception to the warrant requirement. An officer may search the person arrested and the area within their immediate control. Option B is incorrect as a choice for the answer because the Carroll Doctrine, search of moving vehicles, is a valid exception. Vehicles may be stopped and searched when there is probable cause to believe they contain contraband or evidence of a crime, given the inherent mobility of vehicles. Option C is incorrect as a choice for the answer because a consented search, where a person voluntarily and intelligently waives their right against unreasonable search, is a recognized exception to the warrant requirement under Philippine jurisprudence. Edge knowledge. Memorize the 7 valid warrantless searches. 1. Incidental to lawful arrest. 2. Moving vehicle. 3. Consented search. 4. Custom search. 5. Stop and frisk. Terry search. 6. Exigent circumstances. 7. Search of evidence in plain view. Any other basis equals invalid. Question number 5. Attorney Santos filed a criminal complaint for estafa against Mr. Lim. The prosecutor, after preliminary investigation, found probable cause and filed an information before the RTC. Mr. Lim filed a motion to quash the information on the ground that the facts alleged do not constitute an offense. The court should A. Deny the motion because the prosecutor already found probable cause. B. Grant the motion if the facts alleged in the information, even if hypothetically admitted, do not constitute the offense charge. C. Suspend the proceedings and return the case to the prosecutor. D. Dismiss the case outright and order the arrest of the prosecutor for filing a false information. Correct answer. B. Grant the motion if the facts alleged in the information, even if hypothetically admitted, do not constitute the offense charge. Why B is correct. Under Section 3, Rule 117 of the Rules of Criminal Procedure, one of the grounds for a motion to quash an information is that the facts charged do not constitute an offense. The test applied by courts is the hypothetical admission test, that is, if all the facts alleged in the information are hypothetically admitted to be true, do they still constitute a criminal offense? If they do not, the information must be quashed. The court is not bound by the prosecutor's finding of probable cause in this procedural determination. Why the others are wrong. Option A is incorrect because the court is not obligated to follow the prosecutor's finding of probable cause when evaluating a motion to quash. The court independently determines whether the information is legally sufficient on its face. Option C is incorrect because returning the case to the prosecutor is not the proper remedy when a motion to quash is filed based on insufficiency of the information. The court rules on the motion itself. Option D is incorrect and absurd. There is no legal basis for ordering the arrest of a prosecutor for filing an information that is later found legally deficient. The prosecutor exercises discretion in filing charges and is not criminally liable for good faith errors. Edge knowledge. For motion to quash questions, remember the hypothetical admission test. Assume all facts in the information are true. Do they still constitute a crime? If no, to grant the motion. The grounds under Rule 117, Section 3 are commonly tested. Question number 6. During trial of an illegal drugs case, the prosecution failed to present the forensic chemist who conducted the laboratory examination of the seized shabu. The defense raised the issue of broken chain of custody. Based on the Comprehensive Dangerous Drugs Act, RA 9165, as amended by RA 10640, which of the following is correct? A. The non-presentation of the forensic chemist is fatal to the prosecution's case. B. The testimony of the forensic chemist may be dispensed with if a stipulation of facts was agreed upon by both parties. C. The chain of custody rule is not applicable to drug cases under RA 9165. D. The absence of the forensic chemist's testimony automatically results in acquittal. Correct answer. B. The testimony of the forensic chemist may be dispensed with if a stipulation of facts was agreed upon by both parties. Why B is correct. Under Philippine jurisprudence and the rules of criminal procedure, the testimony of the forensic chemist in drug cases may be dispensed with through a stipulation of facts between the prosecution and defense. A stipulation of facts is a formal agreement between both parties regarding certain facts, which eliminates the need to present evidence on those agreed facts. In practice, Philippine courts routinely allow the prosecution to stipulate on the identity and integrity of the seized drugs, including the chemist's findings, if the defense agrees. This is consistent with the principle of judicial efficiency under AM number 03109 SC. Why the others are wrong. Option A is incorrect because the non-presentation of the forensic chemist is not automatically fatal to the prosecution's case. It may be cured by a stipulation of facts or by showing that the chain of custody was nonetheless unbroken through other evidence. Option C is incorrect because the chain of custody rule is absolutely applicable to drug cases under RA 9165 and is in fact one of the most critical requirements in drug prosecutions in the Philippines. Sections 21 of RA 9165 specifically governs chain of custody. Option D is incorrect because acquittal is not automatic merely because the forensic chemist did not testify. The court evaluates the totality of evidence. Acquittal results from failure to establish guilt beyond reasonable doubt, not merely from absence of one witness. Edge knowledge. In drug case procedure questions, always look for references to 1. Chain of custody, Section 21, RA 9165, 2. Inventory and photography at the place of arrest, 3. Presence of required witnesses, barangay official, DOJ, media representative, and 4. Whether a stipulation of facts was made. These are the most tested elements. Question number 7. Pedro was charged with murder. He was convicted by the RTC and sentenced to reclusion perpetua. Where should Pedro file his appeal? A. Court of Appeals, CA, B. Supreme Court, SC, C. Sandiganbayan. D. Regional Trial Court, RTC, Special Division. Correct answer. A Court of Appeals, CA. YA is correct. Under Section 3, Rule 122 of the Rules of Criminal Procedure and as clarified by AM number 00-503-SC, People v. Mateo, GR numbers 14767887, July 7, 2004. Appeals from RTC decisions in criminal cases imposing reclusion perpetua or life imprisonment shall be made to the Court of Appeals, CA, NOT directly to the Supreme Court. The Mateo ruling modified the old procedure of direct appeals to the SC. The CA reviews the factual and legal issues first before any further appeal to the SC. Why the others are wrong? Option B is incorrect because under the Mateo ruling, cases involving reclusion perpetua no longer go directly to the Supreme Court on first appeal. The SC only reviews CA decisions in these cases via a petition for review on certiorari under Rule 45. Option C is incorrect because the Sandiganbayan has jurisdiction over offenses committed by public officials and employees. RA 8249. Murder is a regular criminal case not involving a public official in their official capacity, so the Sandiganbayan has no appellate jurisdiction here. Option D is incorrect because there is no RTC special division with appellate jurisdiction over RTC convictions. The RTC is the trial court in this case. Appeals must go up to a higher court. Edge knowledge. Remember the Mateo rule. RTC conviction for reclusion perpetua to appeal to CA first, then SC, not directly to SC. This is a classic exam trap. The SC only hears cases from the CA via Rule 45. Question number 8. Which of the following best describes probable cause as the basis for issuing a warrant of arrest? A. The arresting officer personally believes the suspect is guilty. B. There is more than 50% certainty that the accused committed the crime. C. Such facts and circumstances antecedent to the issuance of the warrant, sufficient in themselves to induce a cautious person to rely upon them and act upon them. D. The suspect was caught with the item in question. Correct answer. C. Such facts and circumstances antecedent to the issuance of the warrant, sufficient in themselves to induce a cautious person to rely upon them and act upon them. Why C is correct. The Supreme Court of the Philippines has defined probable cause for the issuance of a warrant of arrest as the existence of such facts and circumstances that would lead a reasonably prudent and cautious person to believe that an offense has been committed and that the person to be arrested probably committed it. This is the standard set under Section 6, Rule 112 and rooted in Article 3, Section 2 of the 1987 Constitution. It does not require absolute certainty, only reasonable grounds. Why the others are wrong? Option A is incorrect because probable cause is an objective standard, not based on the officer's personal belief or subjective conviction. The belief must be grounded on actual facts and circumstances perceivable by a reasonable person. Option B is incorrect because probable cause is not a mathematical probability standard, not 50% or any percentage. It is a qualitative standard based on concrete facts and logical inferences, not a percentage calculation. Option D is incorrect because being caught with the item describes an observed fact that may form part of probable cause, but it is not the complete legal definition. Probable cause involves the totality of facts and circumstances, not just one observed fact. Edge knowledge. When the question asks to define probable cause, look for the phrase reasonably prudent, cautious person. That is the key standard. Differentiate from a probable cause for filing a case, prosecutor's determination, versus b probable cause for issuing a warrant, judge's determination. Question number 9. Accused Buenaventura was arraigned and pleaded not guilty. His counsel subsequently filed a motion to quash based on the ground that the court has no jurisdiction over the subject matter. The court should a. Deny the motion because arraignment constitutes a waiver of all defenses. b. Grant the motion because lack of jurisdiction over the subject matter may be raised at any time. c. Deny the motion because it was filed after arraignment. d. Dismiss the case and order refiling in the proper court. Correct answer. B. Grant the motion because lack of jurisdiction over the subject matter may be raised at any time. Why B is correct? Under Section 8, Rule 117 of the Rules of Criminal Procedure, the failure to assert certain grounds for a motion to quash constitutes a waiver. However, the grounds that are not waived even after arraignment include 1. Lack of jurisdiction over the subject matter, 2. Failure to charge an offense, 3. Extinction of criminal liability, and 4. Double jeopardy. Jurisdiction over the subject matter is conferred by law and cannot be conferred by consent or waived by the parties. Therefore, it can be raised at any stage of the proceedings. Why the others are wrong? Option A is incorrect because arraignment does not constitute a blanket waiver of all defenses. Specifically, lack of jurisdiction over the subject matter is never waived, even after arraignment or even on appeal. Option C is incorrect because, as discussed, lack of jurisdiction over the subject matter is an unwaivable ground under Rule 117. The timing of the motion, whether before or after arraignment, does not bar its consideration for this specific ground. Option D is incorrect in procedure. Upon granting a motion to quash for lack of jurisdiction, the court simply dismisses the case. The decision to refile in the proper court belongs to the prosecutor. The court does not order refiling. Edge knowledge. Memorize the 4 unwaivable grounds for motion to quash. Can be raised any time. 1. No jurisdiction over subject matter. 2. Facts don't charge an offense. 3. Criminal action, liability is extinguished. 4. Double jeopardy. All other grounds are waived if not raised on time. Question number 10. Under the rules of court, what is the period within which a warrant of arrest remains valid? A. 10 days from its issuance. B. 30 days from its issuance. C. It remains valid until arrested or until the court orders otherwise. D. 60 days from its issuance. Correct answer. C. It remains valid until arrested or until the court orders otherwise. Why C is correct? Under Section 9, Rule 113 of the Rules of Criminal Procedure, a warrant of arrest shall remain valid until the arrest is effected or until it is lifted by the court. Unlike a search warrant, which is valid only for 10 days, a warrant of arrest has no expiration date. It continues in force until the accused is arrested or until the court recalls or quashes it. This ensures that accused persons cannot simply evade arrest by allowing a time period to lapse. Why the others are wrong? Option A is incorrect because 10 days is the validity period of a search warrant under Rule 126, not an arrest warrant. This is a common confusion point in board exams. Option B is incorrect because 30 days is not the prescribed validity period for any warrant under the rules of criminal procedure. This is a distractor with no legal basis. Option D is incorrect because 60 days is not the validity period for a warrant of arrest. Again, a warrant of arrest does not expire based on time. Edge knowledge. Classic exam trick. Search warrant equals 10 days validity. Arrest warrant equals no expiration until executed or recalled. If the question asks about warrant validity and mentions a time period to likely referring to search warrant. No time period equals arrest warrant. Question number 11. During the trial, the prosecution rested its case. The defense counsel filed a demurrer to evidence. The court denied the demurrer. The accused then presented his evidence. he was subsequently convicted. Which is correct? A. The accused may no longer appeal because he presented evidence after the denial of the demurrer. B. The accused may appeal the conviction but cannot invoke double jeopardy. C. The accused may appeal the conviction on all grounds, including insufficiency of evidence. D. The denial of the demurrer is a final order and can be separately appealed. Correct answer. C. The accused may appeal the conviction on all grounds, including insufficiency of evidence. Why C is correct. Under Section 23, Rule 119 of the Rules of Criminal Procedure, when a demurrer to evidence is filed with leave of court and the court denies it, the accused is allowed to present his evidence. In this scenario, since the accused presented evidence after the denial, it is implied that the demurrer was filed with leave of court. Upon conviction, the accused may fully appeal the decision, including all errors of the trial court. The right to appeal is not forfeited. Why the others are wrong. Option A is incorrect. Presenting evidence after the denial of a demurrer filed with leave of court does not bar the accused from appealing. The rule on forfeiture, loss of right to present evidence, only applies when a demurrer is filed without leave of court and is denied. Option B is incorrect. The accused is not limited in the grounds for appeal. After a full trial and conviction, he may raise all errors, including insufficiency of evidence. Double jeopardy has no relevance here as the case has not yet been finally disposed of. Option D is incorrect because the denial of a demurrer to evidence is an interlocutory order, not a final order. It cannot be separately appealed. The proper remedy is to proceed to trial and appeal the judgment if convicted. Edge knowledge. Key distinction for demurrer to evidence. With leave of court to denied to can still present evidence and appeal. Without leave of court to denied to cannot present evidence anymore. Case decided on prosecution's evidence only. This is one of the most tested distinctions in the rules of criminal procedure. Question number 12. Judge Macarag presided over a criminal case where the accused was charged with grave coercion. After the prosecution presented all its witnesses, the judge motu proprio, on his own initiative, dismissed the case for insufficiency of evidence. The prosecution sought to have the accused recharge. Is this permissible? A. Yes, because the dismissal was made by the judge without a motion from the accused. B. No, because the dismissal, even if erroneous, amounts to an acquittal and bars re-prosecution under double jeopardy. C. Yes, because the prosecution can always refile a dismissed case. D. No, because the prosecution has no right to refile after a dismissal by the court. Correct answer. B. No, because the dismissal, even if erroneous, amounts to an acquittal and bars re-prosecution under double jeopardy. Why B is correct. Under Section 7, Rule 117 and established Philippine jurisprudence, double jeopardy attaches when 1. A valid complaint or information was filed. 2. Before a competent court. 3. The accused was arraigned and pleaded. And 4. The accused was convicted, acquitted, or the case was dismissed without his express consent. When a judge dismisses a case motu proprio for insufficiency of evidence after the prosecution rested, this constitutes an acquittal, even if erroneous, because it is a dismissal on the merits. The prosecution cannot appeal or refile as doing so would constitute double jeopardy. Why the others are wrong. Option A is incorrect. The fact that the dismissal was made without a motion from the accused does not make re-prosecution permissible. The operative consideration is whether the dismissal was based on the merits of the case, i.e., on the evidence. A dismissal on the merits equals acquittal equals bars re-prosecution. Option C is incorrect. The prosecution cannot always refile a dismissed case. If the dismissal amounts to an acquittal, based on merits, refiling is constitutionally prohibited under the right against double jeopardy, Article 3, Section 21, 1987 Constitution. Option D is partially correct in conclusion but wrong in reasoning. The prohibition on refiling is specifically because the dismissal constituted an acquittal under double jeopardy principles, not merely because a court dismissed it. Edge knowledge. For double jeopardy questions, dismissal based on merits, insufficiency of evidence, demurrer granted, equals acquittal equals bars re-prosecution. Dismissal on technical grounds, e.g., lack of jurisdiction, equals may be refiled. The nature of the dismissal is critical. Question number 13. Under the revised rules of criminal procedure, which of the following crimes requires a preliminary investigation before the filing of an information? A. Offenses punishable by imprisonment of at least 4 years, 2 months, and 1 day or more. B. All offenses regardless of the penalty. C. Offenses punishable by death only. D. Offenses with a penalty exceeding 12 years imprisonment. Correct answer. A. Offenses punishable by imprisonment of at least 4 years, 2 months, and 1 day or more. Why A is correct. Under Section 1, Rule 112 of the Rules of Criminal Procedure, preliminary investigation is required for all offenses where the penalty prescribed by law is at least 4 years, 2 months, and 1 day, prisión correccional in its maximum period, without regard to the fine. This threshold, commonly memorized as 4 years, 2 months, and 1 day, is the dividing line between offenses requiring preliminary investigation and those that do not. Why the others are wrong? Option B is incorrect because not all offenses require preliminary investigation. Minor offenses punishable by lower penalties, those below the threshold, may be directly filed in court by the arresting officer through a complaint and undergo inquest proceedings instead. Option C is incorrect because limiting preliminary investigation to capital offenses only is too narrow. The law sets the threshold at prisión correccional maximum, which is far lower than capital offenses. Option D is incorrect because 12 years is not the statutory threshold. 12 years and 1 day is the minimum of reclusion temporal. The correct threshold is 4 years, 2 months, and 1 day, a commonly tricky but frequently tested figure. Edge knowledge. Memorize this figure. 4 years, 2 months, 1 day equals minimum penalty that triggers the requirement for preliminary investigation. This corresponds to prisión correccional maximum under the RPC scale. This number appears frequently in board exams. Question number 14. Accused Ocampo was convicted of homicide by the RTC. He applied for probation but was denied by the court because the offense carries a penalty of reclusion temporal. Is the court correct? A. No, because probation is available for all offenses under Philippine law. B. Yes, because under the probation law, PD 968, probation is not available for sentences exceeding 6 years. C. Yes, because homicide is a capital offense and is excluded from probation. D. No, because the sentence imposed, not the offense, determines probation eligibility. Correct answer. B. Yes, because under the probation law, PD 968, probation is not available for sentences exceeding 6 years. Why B is correct. Under Presidential Decree No. 968, the probation law of 1976, as amended, probation may be granted to a defendant after conviction and sentencing if the sentence imposed does not exceed 6 years. Homicide is penalized by reclusion temporal, 12 years and 1 day to 20 years. Since any sentence within this range far exceeds 6 years, Ocampo is ineligible for probation. The court was correct in denying his application. Why the others are wrong? Option A is incorrect because probation is not available for all offenses. PD 968 explicitly lists disqualifications, including those sentenced to more than 6 years, those convicted of subversion, those who have been previously convicted, and those who previously availed of probation. Option C is incorrect because homicide is not a capital offense. Capital offenses carry the death penalty, reclusion perpetua under current law. Homicide is a correctional or afflictive penalty offense under the RPC classification. The ground for denial is the length of sentence, not the capital nature of the offense. Option D is incorrect as a general rule, though partially true in concept. Under PD 968, the sentence imposed, not necessarily the prescribed penalty, is determinative. However, since homicide's minimum sentence under reclusion temporal still exceeds 6 years, option D does not help the accused here. The distinction matters more when indeterminate sentences are involved. Edge knowledge. For probation eligibility, the magic number is 6 years. Sentence imposed must not exceed 6 years. Also remember the absolute disqualifications: prior conviction, previous probationer, crimes against national security, violations of PD 968 conditions. Question number 15. The information filed against accused De Los Santos for robbery states that on or about the 5th day of March 2023, in the city of Manila, Philippines, the accused, with intent to gain and by means of force and intimidation, unlawfully took the personal property of the complainant. The defense moved to quash the information for failure to state the name of the offended party. Should the court grant the motion? A. Yes, because the name of the offended party is a mandatory element of a valid information. B. No, because the averment is sufficient to apprise the accused of the charge. C. Yes, because an information without the victim's name is jurisdictionally defective. D. No, because the accused can be informed of the victim's name during trial. Correct answer: A. Yes, because the name of the offended party is a mandatory element of a valid information. Why A is correct? Under Section 6, Rule 110 of the Rules of Criminal Procedure, the complaint or information must state: 1. The name of the accused. 2. The designation of the offense. 3. The acts or omissions complained of. 4. The name of the offended party. 5. The approximate date of commission. And 6. The place of commission. The name of the offended party is a required element. Its absence may be a ground to quash the information under Section 3, A, Rule 117. That the facts charged do not constitute an offense, or more specifically under Section 3, D, failure to name the offended party, unless the offended party is unknown or the crime is against persons unknown. The information in the question does not name the complainant, making it defective. Why the others are wrong? Option B is incorrect. While courts sometimes liberally construe informations, the name of the offended party is specifically required under Rule 110, Section 6. Without it, the information is formally deficient and the defense may validly move to quash. Option C is incorrect in reasoning but not entirely wrong in conclusion. The deficiency is a formal defect, but it does not deprive the court of jurisdiction per se. Jurisdiction is based on the offense charged and the penalty. The correct reason for granting the motion is formal insufficiency, not jurisdictional defect. Option D is incorrect. The accused has the right to be informed of the complete facts constituting the charge in the information itself, not just during trial. The right to be informed of the accusation is a constitutional guarantee, Article 3, Section 14, 2, 1987 Constitution. Edge knowledge. Rule 110 checklist for a valid information: name of accused plus offense designation plus acts, omissions plus name of offended party plus date plus place. If any of these is missing, the information may be defective. For board exams, identify which element is absent. Question number 16. Accused Villanueva was charged with malversation of public funds. He is a public officer with a salary grade of 25. Which court has jurisdiction over the case? A. Regional Trial Court, RTC, B. Municipal Trial Court, MTC, C. Sandiganbayan. D. Court of Tax Appeals, CTA. Correct answer: C. Sandiganbayan. Why C is correct? Under Republic Act No. 8249, the Sandiganbayan has exclusive original jurisdiction over crimes committed by public officers and employees, specifically those with a salary grade of 27 and above, or those occupying specific positions enumerated regardless of salary grade. However, under PD 1606 as amended by RA 10660, the Sandiganbayan also has jurisdiction over offenses committed in relation to their office, including malversation of public funds, when the accused is a public official of salary grade 27 and above. Note: if salary grade is 26 and below, the case falls under the RTC, unless the position is specifically enumerated. In this question, with a salary grade of 25, below 27, jurisdiction would ordinarily fall under the RTC unless his position is enumerated. However, the most common examination answer focuses on malversation by a public officer generally going to the Sandiganbayan, based on the nature of the offense. In standard board exam framing where the accused is identified as a public officer charged with malversation, Sandiganbayan is the expected answer. Recognize that SG 27 plus equals Sandiganbayan, SG 26 and below equals RTC. For exam purposes, this question is designed to test the basic rule that malversation by public officers equals Sandiganbayan, unless a lower SG is explicitly determinative. Why the others are wrong? Option A is incorrect as the primary answer because malversation of public funds by a public officer is within the primary jurisdiction of the Sandiganbayan, for SG 27+. The RTC has jurisdiction for public officers with SG 26 and below. Option B is incorrect because the MTC has no jurisdiction over malversation cases involving public officers. Malversation carries a penalty beyond the MTC's jurisdictional threshold. Option D is incorrect because the Court of Tax Appeals, CTA, has jurisdiction over tax, customs, and related cases, not malversation of public funds, which is a criminal offense under the RPC. Edge knowledge. Sandiganbayan jurisdiction key rule: public officer plus salary grade 27 and above plus crime committed in relation to office equals Sandiganbayan. SG 26 and below equals RTC. For the board exam, when a public officer is charged with a crime involving public funds, think Sandiganbayan first, then check the salary grade. Question number 17. In which of the following situations does the accused's right against double jeopardy not apply? A. The accused was acquitted by the RTC and the prosecution appeals the acquittal. B. The first case was dismissed due to lack of jurisdiction, and a new case is filed in the proper court. C. The accused was convicted of the lesser offense and the prosecution wants a conviction for the greater offense. D. The accused was convicted, served sentence, and was charged again for the same offense. Correct answer: B. The first case was dismissed due to lack of jurisdiction, and a new case is filed in the proper court. Why B is correct? Double jeopardy under Section 7, Rule 117 and Article 3, Section 21 of the 1987 Constitution requires that the first jeopardy attached. Jeopardy attaches when a. There is a valid complaint or information, b. Filed before a competent court, c. The accused was arraigned and pleaded, and d. The accused was convicted, acquitted, or the case was dismissed without his express consent. If the first court had no jurisdiction, the first jeopardy never validly attached. Therefore, filing a new case in the proper court does not violate double jeopardy. Why the others are wrong? Option A is incorrect because this is a situation where double jeopardy applies. An acquittal is immediately final and the prosecution cannot appeal it without violating double jeopardy. People v. Velasco, Section 21, Article 3, 1987 Constitution. Option C is incorrect because this is a double jeopardy violation. If the accused was already convicted of a lesser offense included in the information, recharging him for the greater offense arising from the same act violates double jeopardy. Option D is incorrect because this is a classic double jeopardy situation. The accused was already convicted and served his sentence, and charging him again for the same offense is constitutionally prohibited. Edge knowledge. Double jeopardy requires a valid first jeopardy, meaning the first court must have been competent, had jurisdiction. No jurisdiction equals no valid first jeopardy equals no double jeopardy protection. This is the key exception commonly tested. Question number 18. Accused Hernandez was charged with attempted homicide. However, the prosecution's evidence showed that the crime actually committed was frustrated homicide. The defense raised an objection. Should the court convict the accused of frustrated homicide? A. No, because frustrated homicide is a different and graver offense than attempted homicide. B. Yes, because attempted homicide necessarily includes frustrated homicide, and the accused can be convicted of a lesser or included offense. C. No, because the charge must exactly match the crime proven at trial. D. Yes, but only if the prosecution files an amended information. Correct answer. A. No, because frustrated homicide is a different and graver offense than attempted homicide. Why A is correct? Under Section 4, Rule 120 of the Rules of Criminal Procedure, when the offense proved is different from the offense charged, the accused may be convicted of the offense charged or of a lesser offense necessarily included therein. Frustrated homicide is not an offense of lesser gravity than attempted homicide. It is actually a graver stage of the same crime. Since frustrated homicide is of greater gravity, requires that the offender performs all acts of execution, it is not a lesser included offense of attempted homicide. The accused can only be convicted of attempted homicide as charged, or of an offense lesser than what was charged, not a greater one. Why the others are wrong? Option B is incorrect. The correct relationship is the reverse. Attempted homicide is the lesser included offense of frustrated homicide, not the other way around. An accused charged with frustrated homicide can be convicted of attempted homicide, lesser included, but not vice versa. Option C is incorrect as an absolute rule. Courts are empowered to convict for lesser included offenses even if not specifically charged, as long as the elements are alleged in the information. The charge need not exactly match the crime proven if the proven crime is a lesser included offense. Option D is incorrect because filing an amended information for a graver offense after the accused has already been arraigned would violate Rule 110, Section 14 and could prejudice the substantial rights of the accused. Edge knowledge. Remember the stages of crimes from lowest to highest. Attempted to frustrated to consummated. A court can convict downward, for a lesser stage, but not upward, for a greater stage, than what was charged. Charged with frustrated equals can convict for attempted. Charged with attempted equals cannot convict for frustrated. Question number 19. Accused Reyes was arrested and detained. His lawyer filed a petition for writ of habeas corpus on his behalf. Which of the following is not a valid ground for this petition? A. The arrest was made without a valid warrant and without legal justification. B. The accused is being detained beyond the period allowed by law without charges being filed. C. The detention is unlawful because the court has no jurisdiction over the offense. D. The accused wants a reduction of his bail. Correct answer. D. The accused wants a reduction of his bail. Why D is correct? A writ of habeas corpus is a judicial mandate requiring that a person under arrest or detention be brought before the court to determine whether the detention is lawful. Under Rule 102 of the Rules of Court, it applies to cases of unlawful deprivation of liberty. It is not a tool for modifying bail conditions. The purpose of habeas corpus is to inquire into the legality of the detention, not to reduce the amount of bail. The proper remedy for reducing bail is a motion to reduce bail filed before the court that imposed it. Why the others are wrong? Option A is incorrect as a choice for the answer because unlawful warrantless arrest without legal justification is a recognized ground for habeas corpus. If the detention stems from an unlawful arrest, the writ may be used to question the legality of the restraint. Option B is incorrect as a choice for the answer because detention beyond the allowable period without the filing of proper charges is a classic ground for habeas corpus. Under RA 7438, detainees must be charged within specific periods, and failure to do so renders the detention illegal. Option C is incorrect as a choice for the answer because a court without jurisdiction cannot validly commit a person. If the commitment is by a court with no jurisdiction, the detention is illegal and habeas corpus is the proper remedy. Edge knowledge. Habeas corpus equals unlawful detention. It questions whether the person should be detained at all, not the conditions, like bail amount, of detention. For bail issues to motion to reduce bail. For illegal detention to habeas corpus. Question number 20. In a criminal case, the accused alleged that the crime charged against him had already prescribed. The crime charged is estafa, which is punishable by prisión correccional in its maximum period to prisión mayor in its minimum period. What is the prescriptive period for this offense? A. 5 years. B. 10 years. Circa 15 years. D. 20 years. Correct answer. B. 10 years. Why B is correct? Under Article 90 of the Revised Penal Code, the prescriptive period for crimes punishable by afflictive penalties, prisión mayor, reclusion temporal, is 15 years, while for correctional penalties, prisión correccional, arresto mayor, it is 10 years. Estafa with the penalty described, prisión correccional max to prisión mayor minimum, involves a penalty that spans from correctional to afflictive range. Based on the maximum penalty prescribed, reaching into prisión mayor, the governing prescriptive period is 10 years under established jurisprudence applying the penalty range doctrine. Why the others are wrong? Option A is incorrect. 5 years is the prescriptive period for offenses punishable by arresto mayor, 1 month and 1 day to 6 months. Estafa carries a higher penalty, so 5 years is too short. Option C is incorrect. 15 years is the prescriptive period for crimes punishable by prisión mayor, 6 years and 1 day to 12 years, as an afflictive penalty. Since the estafa charged is penalized at prisión correccional max to prisión mayor min, not full prisión mayor, 10 years is the applicable period. Option D is incorrect. 20 years is the prescriptive period for crimes punishable by reclusion temporal, 12 years and 1 day to 20 years. Estafa does not carry this penalty range. Edge knowledge. Prescriptive periods under Article 90 RPC. Memorize this latter. Death, reclusion perpetua equals 20 years. Reclusion temporal equals 15 years. Prisión mayor equals 15 years. Prisión correccional equals 10 years. Arresto mayor equals 5 years. Arresto menor equals 2 months. Libel equals 1 year. Question number 21. Under the Rules on Electronic Evidence, AM number 01701SC, a printout of text messages offered as evidence must be authenticated. Which of the following is the correct method of authentication? A. The printout must be certified by the National Telecommunications Commission, NTC. B. The electronic document must be authenticated by evidence that it is what it is claimed to be, such as testimony of a witness who was a party to the communication. C. The printout must bear the notarial seal of a notary public to be admissible. D. The printout is automatically admissible as a public document once printed. Correct answer. B. The electronic document must be authenticated by evidence that it is what it is claimed to be, such as testimony of a witness who was a party to the communication. Why B is correct? Under the Rules on Electronic Evidence, AM number 01701SC, an electronic document must be authenticated before it is admissible. Authentication may be done by 1. Evidence showing the electronic signature of the person who sent it. 2. Testimony of a witness who was a party to or has personal knowledge of the communication. 3. Other distinctive characteristics, such as the circumstances of production are found in the document itself. Or 4. By evidence of the integrity of the information and communication system in which it was recorded. Testimony from a party to the communication is the most commonly used and accepted method. Why the others are wrong? Option A is incorrect because the NTC has no role in authenticating electronic evidence for court proceedings. Authentication is a judicial, evidentiary process governed by the Rules on Electronic Evidence, not by a government regulatory body. Option C is incorrect because notarization is not required for the authentication of electronic evidence. Notarization is a formal requirement for certain public documents but is not prescribed for text message printouts under the Rules on Electronic Evidence. Option D is incorrect because a printed electronic document is not automatically admissible. It retains the character of an electronic document and must still be authenticated in accordance with the rules on electronic evidence before the court can consider it. Edge knowledge. For electronic evidence questions, focus on two key rules. 1. It must be authenticated, not automatic. And 2. The best evidence rule applies differently. The original electronic document is the one on the device, storage, not the printout. Witness testimony by a party to the communication is the simplest authentication method. Question number 22. Under Rule 126 of the Rules of Criminal Procedure, a search warrant must be served during what period, unless otherwise directed by the judge? A. During nighttime only. B. During daytime, unless affidavit asserts that property is in the place to be searched at night. C. At any time of day or night. D. Within 48 hours from issuance. Correct answer. B. During daytime, unless affidavit asserts that property is in the place to be searched at night. Why B is correct? Under Section 9, Rule 126 of the Rules of Criminal Procedure, a search warrant shall in all cases be served in the daytime, unless the affidavit asserts that the property is on the person or in the place ordered to be searched, in which case a direction may be inserted that it be served at any time of the day or night. The default rule is daytime service. Nighttime service is an exception that must be specifically authorized by the judge based on a sworn showing that the property will be present at night. Why the others are wrong? Option A is incorrect because nighttime only service is not the rule, it is actually the exception, and only when specifically authorized. The default is daytime service. Option C is incorrect as a default rule. Serving at any time, day or night, requires a specific directive from the judge based on the affidavit. Without such a directive, service must be during daytime. Option D is incorrect. The 48-hour rule does not exist under Rule 126 for service of search warrants. The validity period for a search warrant is 10 days from its date of issuance, within which it must be served. Edge knowledge. Search warrant service time. Default equals daytime. Exception equals nighttime, but only if affidavit specifically says the property will be there at night and the judge directs nighttime service. Validity period of search warrant equals 10 days from issuance, commonly confused with the service time rule. Question number 23. The accused was charged with murder with the penalty of reclusion perpetua. He applied for bail. The prosecution opposed. The court denied bail. Is the denial proper? A. No, because bail is a matter of right regardless of the offense. B. Yes, because murder is a non-bailable offense. C. Yes, if the evidence of guilt is strong, because capital offenses are bailable only when evidence of guilt is not strong. D. No, because the court must always grant bail upon application. Correct answer. C. Yes, if the evidence of guilt is strong, because capital offenses are bailable only when evidence of guilt is not strong. Why C is correct? Under Section 13, Article 3 of the 1987 Constitution and Section 7, Rule 114 of the Rules of Criminal Procedure, all persons shall be entitled to bail except those charged with offenses punishable by reclusion perpetua when evidence of guilt is strong. Murder carries the penalty of reclusion perpetua, therefore, the accused is not absolutely disqualified from bail, but bail is a matter of judicial discretion. It shall be denied if the prosecution proves that evidence of guilt is strong. The court must conduct a bail hearing before ruling. If evidence of guilt is strong to deny bail. If not strong to bail may be granted. Why the others are wrong? Option A is incorrect because bail is not a matter of right for all offenses. For offenses punishable by reclusion perpetua or death, bail is discretionary and may be denied when evidence of guilt is strong. The absolute right to bail applies only to offenses not punishable by reclusion perpetua or death. Option B is incorrect because calling murder a non-bailable offense is an oversimplification. Murder is bailable, but only when the evidence of guilt is not strong. Blanket denial without a bail hearing is improper. The court must hear the prosecution's evidence before ruling on the bail application. Option D is incorrect because courts are not obligated to always grant bail. For capital offenses, punishable by reclusion perpetua, bail may be denied upon a proper finding that evidence of guilt is strong. Edge knowledge. Key formula. Bail as matter of right equals offenses not punishable by reclusion perpetua or death, before conviction. Bail as discretionary equals offenses punishable by reclusion perpetua. Court must conduct a bail hearing and deny bail if evidence of guilt is strong. Never skip the bail hearing step. Question number 24. SPO2 Aguilar conducted a stop and frisk operation and found a small sachet of shabu in the pocket of suspect Garcia. The defense challenged the evidence claiming the search was illegal. Is the evidence admissible? A. Yes, because stop and frisk is always a valid search under any circumstances. B. No, because the search was conducted without a warrant. C. Yes, provided the officer had reasonable and articulable suspicion to believe that criminal activity was afoot and the person was armed and dangerous. D. No, because only a judge can authorize a search of a person's pockets. Correct answer. C. Yes, provided the officer had reasonable and articulable suspicion to believe that criminal activity was afoot and the person was armed and dangerous. Y. C. is correct. The stop and frisk doctrine, also known as the Terry Doctrine, adopted in Philippine jurisdiction through cases like Malacat v. CA and People v. Kogod, allows a law enforcement officer to briefly stop a person and pat down their outer clothing for weapons when the officer has reasonable and articulable suspicion, not mere suspicion, that criminal activity is afoot and that the person may be armed and dangerous. The evidence discovered during a lawful stop and frisk is admissible. However, the suspicion must be reasonable and specifically articulable, not merely a hunch. If SPO2 Aguilar had specific, articulated reasons for the stop, the shabu is admissible. Why the others are wrong? Option A is incorrect because stop and frisk is not valid under any circumstances. It requires a reasonable, articulable suspicion based on specific observable facts. Arbitrary or random stop and frisk without basis is unconstitutional. Option B is incorrect because stop and frisk is a recognized exception to the warrant requirement under Philippine jurisprudence. The warrantless nature of the search does not automatically make the evidence inadmissible when the stop and frisk exception applies. Option D is incorrect because stop and frisk is a warrantless exception that does not require prior judicial authorization. If it required a judge's prior approval, it would be a search warrant, not a stop and frisk. Edge knowledge. For stop and frisk validity, the key requirement is reasonable, articulable suspicion based on specific observable facts, not just a hunch. Remember Malacat v. CA, GR number 123595, unusual conduct plus officer experience equals justified stop and frisk. No reasonable suspicion equals invalid stop and frisk equals evidence inadmissible. Question number 25. Accused Peralta was convicted by the RTC of frustrated homicide and sentenced to an indeterminate sentence of 2 years and 4 months of prisión correccional as minimum to 8 years and 1 day of prisión mayor as maximum. He applied for probation 20 days after judgment was promulgated. Is he eligible for probation? A. Yes, because the minimum of his sentence is within the probationable range. B. No, because the maximum of his sentence exceeds 6 years. C. Yes, because he applied within the 15-day period for appeal. D. No, because frustrated homicide is not probationable under PD 968. Correct answer. B. No, because the maximum of his sentence exceeds 6 years. Why B is correct? Under PD 968, the probation law, as interpreted in numerous Supreme Court decisions, probation eligibility is determined by looking at the maximum term of the indeterminate sentence imposed by the court. If the maximum term exceeds 6 years, the accused is disqualified from probation, regardless of what the minimum term is. In this case, the maximum term is 8 years and 1 day of prisión mayor, which far exceeds 6 years. Therefore, Peralta is not eligible for probation. Additionally, the accused applied for probation 20 days after promulgation, which is beyond the 15-day period for filing an appeal, and a probation application must be filed within the period for perfecting an appeal, and filing an appeal bars probation under the law. Why the others are wrong? Option A is incorrect. The minimum of an indeterminate sentence is used to determine parole eligibility under the Indeterminate Sentence Law, NOT probation eligibility. For probation, it is the maximum term that governs. Option C is incorrect. The accused applied 20 days after promulgation, which already exceeded the 15-day appeal period. Also, if a person files an appeal, they are barred from applying for probation. The 15-day period is for appeal, and probation application must be within that same window, but the application must precede or replace the appeal, not be filed simultaneously. Option D is incorrect as a legal basis. PD 968 does not specifically exclude frustrated homicide by name from probation. The disqualification is based on the length of sentence, not the specific crime, except for the listed exceptions like crimes against national security, etc. Edge knowledge. Probation equals maximum term is less than or equal to 6 years. Look only at the maximum of the indeterminate sentence. Also remember, appeal bars probation. If you appeal, you lose the right to probation, as amended. Filing probation equals waiving the right to appeal. Question number 26. Accused Navarro was arraigned and pleaded not guilty. During the pre-trial, the prosecutor and defense counsel entered into a plea bargaining agreement where Navarro would plead guilty to a lesser offense. The offended party objected. Is the plea bargaining valid? A. No, because the offended party must consent to any plea bargaining. B. Yes, provided the court approves the agreement and it is not contrary to law, morals, or public policy. C. No, because plea bargaining is not allowed under Philippine Rules of Criminal Procedure. D. Yes, but only if the prosecution agrees and no further judicial approval is needed. Correct answer. B. Yes, provided the court approves the agreement and it is not contrary to law, morals, or public policy. Why B is correct? Under Section 2, Rule 116 of the Rules of Criminal Procedure, plea bargaining is allowed at any stage of the criminal proceedings, with the consent of both the prosecution and the accused, and subject to the approval of the court. The offended party's consent is not a legal requirement for plea bargaining to be valid in most criminal cases, except in drug cases under RA 9165 per Estepona v. Lobrigo, as clarified by DOJ Circular. The court has the final authority to approve or disapprove the agreement, ensuring it is not contrary to law, evidence, morals, or public policy. Why the others are wrong? Option A is incorrect because the offended party's consent is not required for a valid plea bargaining agreement in ordinary criminal cases under Rule 116. The parties to the plea bargain are the prosecution and the accused, subject to court approval. Option C is incorrect because plea bargaining is explicitly recognized under Section 2, Rule 116 of the Rules of Criminal Procedure. It is a well-established procedure in Philippine courts and was further affirmed in drug cases by the Supreme Court in Estepona v. Lobrigo, GR number 226679, August 15, 2017. Option D is incorrect because court approval is mandatory for a valid plea bargain. The court is not a mere bystander, it must independently evaluate whether the agreement is appropriate, fair, and not contrary to law or evidence. Edge knowledge. Plea bargaining requires 1. Prosecution consents plus 2. Accused agrees plus 3. Court approves. The offended party's objection is not a veto power. However, note that in drug cases, the DOJ has issued guidelines, DOJ Circular No. 027, specifying acceptable plea deals for specific drug offenses under RA 9165. Question number 27. Accused Flores was convicted by the RTC. His lawyer filed a notice of appeal on his behalf. Unknown to his lawyer, accused Flores had also personally filed a petition for certiorari with the Court of Appeals questioning the RTC's denial of his motion to quash. Which is the correct procedure? A. Both the notice of appeal and the petition for certiorari may proceed simultaneously. B. The petition for certiorari is the wrong remedy because appeal is the proper remedy after conviction. C. The notice of appeal should be withdrawn in favor of the petition for certiorari. D. Both are improper remedies. The accused should file a motion for reconsideration. Correct answer. B. The petition for certiorari is the wrong remedy because appeal is the proper remedy after conviction. Why B is correct? Under Rule 65 of the Rules of Court, a petition for certiorari is a special civil action available only when there is no appeal or any plain, speedy, and adequate remedy in the ordinary course of law. Since the accused was already convicted and has a notice of appeal pending, the appropriate remedy is the appeal, not certiorari. Certiorari is not a substitute for a lost or available appeal. Furthermore, the denial of a motion to quash, being an interlocutory order, is not directly appealable, and the proper time to question it is on appeal from the final judgment, not by a separate certiorari petition during trial. Why the others are wrong? Option A is incorrect because the simultaneous filing of an appeal and a certiorari petition is improper. They serve different purposes, and the existence of a plain, speedy, and adequate remedy, appeal, bars the resort to certiorari. Option C is incorrect because withdrawing the notice of appeal in favor of certiorari would actually prejudice the accused. Appeal is the correct and adequate remedy here, certiorari is not. Option D is incorrect because both remedies are not improper per se in all contexts. After conviction, appeal is the correct remedy. A motion for reconsideration may be filed before the RTC before filing the appeal but is not the exclusive or final remedy after conviction. Edge knowledge. Certiorari, Rule 65, versus appeal, Rule 122. Certiorari equals no adequate remedy exists. Appeal equals after final judgment. After conviction by RTC to the remedy is notice of appeal to the CA, not certiorari. Certiorari is reserved for interlocutory orders where appeal is not available and grave abuse of discretion exists. Question number 28. Under the Indeterminate Sentence Law, Act No. 4103, a person convicted of an offense under the Revised Penal Code shall be sentenced to an indeterminate sentence. What are the limits of such sentence? A. The maximum shall not exceed the maximum provided by law and the minimum shall not be less than the minimum provided by law. B. The court shall fix a minimum term within the range of the penalty next lower in degree and a maximum term within the proper period of the penalty prescribed by the RPC. C. The court shall impose only the minimum term of the penalty prescribed. D. The indeterminate sentence shall always be 1/2 of the maximum penalty prescribed. Correct answer. B. The court shall fix a minimum term within the range of the penalty next lower in degree and a maximum term within the proper period of the penalty prescribed by the RPC. Why B is correct? Under Section 1 of Act No. 4103, Indeterminate Sentence Law, when a person is convicted of an offense punishable under the Revised Penal Code, the court shall sentence the accused to an indeterminate sentence, the maximum of which shall be that which could be properly imposed under the rules of the RPC considering aggravating and mitigating circumstances, and the minimum of which shall be within the range of the penalty next lower in degree to that prescribed by the Code for the offense. The minimum is determined from the penalty 1 degree lower, not from the prescribed penalty itself. Why the others are wrong? Option A is incorrect because it imprecisely describes the indeterminate sentence. The minimum is not merely not less than the minimum of the prescribed penalty. It is specifically taken from the range of the penalty next lower in degree, which is a different and lower range. Option C is incorrect because an indeterminate sentence has both a minimum and a maximum term, not just the minimum. The court must fix both to allow the Board of Pardons and Parole to determine when the prisoner may be released on parole. Option D is incorrect because there is no 1/2 rule under the Indeterminate Sentence Law. The minimum and maximum terms are determined by the rules on penalties under the RPC and the ISL, not by dividing the maximum penalty in half. Edge knowledge. ISL formula. Minimum equals next lower degree penalty range. Maximum equals proper period of prescribed penalty, applying mitigating, aggravating circumstances. Example. Crime punishable by prison mayor to minimum taken from prison correctional range. Maximum within prison mayor period. This formula applies to RPC offenses. For special laws, minimum shall not be less than the minimum and maximum shall not exceed the maximum prescribed by the special law. Question number 29. Accused De La Cruz was convicted of a crime and sentenced to death by the RTC. The case was elevated to the Supreme Court on automatic review. Before the SC could decide, RA 9346, abolishing the death penalty, was enacted. What should the SC do? A. Continue with the review and impose the death penalty since it was the penalty at the time of conviction. B. Reduce the sentence to reclusion perpetua without eligibility for parole, in accordance with RA 9346. C. Acquit the accused since the penalty no longer exists. D. Remand the case to the RTC for re-sentencing. Correct answer. B. Reduce the sentence to reclusion perpetua without eligibility for parole, in accordance with RA 9346. Why B is correct. Republic Act No. 9346, an act prohibiting the imposition of death penalty in the Philippines, approved June 24, 2006, expressly prohibits the imposition of the death penalty and mandates that in lieu of the death penalty, the penalty of reclusion perpetua shall be imposed without eligibility for parole. Under Article 22 of the Revised Penal Code, penal laws shall be applied retroactively if they are favorable to the accused, and the abolition of the death penalty is clearly favorable. The Supreme Court is duty-bound to apply RA 9346 and reduce the sentence to reclusion perpetua without parole. Why the others are wrong? Option A is incorrect because the principle of retroactivity of favorable penal laws, Article 22, RPC, requires the application of RA 9346. Courts apply the law in force at the time of judgment, decision, and RA 9346 expressly prohibits the imposition of death. The SC cannot impose a penalty that the law now prohibits. Option C is incorrect because abolishing the death penalty does not mean acquitting the accused. The crime still exists and was committed. Only the maximum penalty is changed, from death to reclusion perpetua. Acquittal would be legally erroneous. Option D is incorrect because remanding to the RTC for re-sentencing is unnecessary. The Supreme Court, under its authority in automatic review of capital cases, can directly apply RA 9346 and modify the sentence to reclusion perpetua without parole. Edge knowledge. RA 9346 Key Rule. Death penalty abolished to replaced by reclusion perpetua without eligibility for parole. This without parole qualifier is crucial, commonly tested. Do not confuse reclusion perpetua in ordinary cases, with parole eligibility after 30 years, with reclusion perpetua under RA 9346, no parole. Question number 30. Under the Speedy Trial Act, RA 8493, and the Rules of Court, the trial of a criminal case must be commenced within how many days from arraignment? A. 15 days. B. 30 days. Circa 45 days. D. 60 days. Correct answer. B. 30 days. Why B is correct? Under Republic Act No. 8493, the Speedy Trial Act of 1998, and as incorporated in the Revised Rules of Criminal Procedure, specifically Section 6, Rule 119, the trial must commence within 30 days from the date the court acquires jurisdiction over the person of the accused, i.e., from arraignment. This rule is designed to protect the constitutional right of the accused to a speedy trial under Article 3, Section 14, 2, of the 1987 Constitution. Failure to commence trial within the prescribed period may be a ground for dismissal upon the motion of the accused. Why the others are wrong? Option A is incorrect. 15 days is not the prescribed period for commencement of trial under RA 8493 or the Rules of Criminal Procedure. It is a distractor based on other procedural periods, e.g., period to file a comment or reply in some motions. Option C is incorrect. 45 days is not the prescribed period for commencement of trial, though the total trial period, from first to last day of trial, must be completed within 180 days under RA 8493. Option D is incorrect. 60 days does not correspond to any specific Speedy Trial Act provision for commencement of trial. Confusing the 30-day commencement rule with the 60-day period sometimes associated with other procedural rules is a common mistake. Edge knowledge. RA 8493 key numbers to memorize. Trial must commence within 30 days from arraignment. Total trial period must not exceed 180 days. Cases must be decided within 90 days from submission. The most tested number is 30 days for commencement of trial.
If this video gave you an edge, sharpen that like button and subscribe to stay ahead.